Dear students, viewers, and the subscribers, welcome to our next lecture on the series Indian Polity. This would be our lecture number 72 in the series, and you are watching this in the channel The IAS Mentor. The very objective of this particular series is to provide a comprehensive idea about the subject Indian Polity for the students preparing for the UPSC IAS examination. And of course, it will also be helpful for the students preparing for the other competitive examination. So this series is made keeping in mind the requirements in the prelims examination and also the mains examination, what the questions that can be asked in GS paper 2. So with that, we'll enter into the topic today. The topic that you're going to discuss today is the qualifications and the disqualifications of the members of the parliament. Now, before I get into the qualifications and disqualification, I'll also discuss a small topic as to the term of the Lok Sabha and of course, the Rajya Sabha is a permanent house, but yes, what is the term of the members? We'll discuss about all those things. Now, once I complete discussing that, then we are going into the qualifications and the disqualifications. Qualification means what are the qualifications one possesses to contest election to become a member of parliament, that is to be a member of Lok Sabha or Rajya Sabha. Disqualification deals with two things: disqualification for being chosen as a member of parliament and the disqualification for someone who is already a member of parliament. So there are certain grounds that is given in the constitution as to what can disqualify one from being chosen as a member of parliament, and if he is already elected as a member of parliament, then also he can be disqualified under these grounds. So we'll try to understand that all by one. Very important topic. And one of the important aspects of disqualification from being a member of parliament is also what is called as anti-defection law. I'll also give an essence of anti-defection law in today's class, but maybe I'll deal with that in detail in the next class. But however, yes, we'll try to understand the other qualifications and disqualifications of the members of the parliament. But before that, let us first try to understand the duration of the houses. Duration means what is the term of the houses of the parliament, what is given in the constitution in relation to that. If you see the term of the Lok Sabha is normally for a period of 5 years. So that's a normal term. It is not necessary in all the cases. The term of the Lok Sabha is always 5 years. So presently we are in what Lok Sabha? The first Lok Sabha came in 1952. So presently we are in which Lok Sabha? If you know the answer, please put it in the comment box. So often I ask questions to the students so that I can engage with the students. Let me also understand to what extent students are taking these lectures very seriously. So in 2024, the elections happened, and that is whether it is the 16th Lok Sabha, the 17th Lok Sabha, the 18th Lok Sabha, the 19th Lok Sabha. I'm giving options also. You can put the answers in the comment box. Okay. Whenever the Lok Sabha is elected, what is the normal term of the Lok Sabha? It is 5 years, but it is not necessarily always the term of the Lok Sabha is 5 years. The Lok Sabha can be dissolved at an earlier date, even before completing 5 years term, or it can be extended also under a specific condition. So normally when it gets dissolved even before 5 years term, normally the Lok Sabha is dissolved when the Council of Ministers are dismissed. When the Council of Ministers are dismissed, usually when there is a no confidence motion. So when a no confidence motion is passed, we know that in a parliamentary democracy, the government is elected and that government should always have a majority in the Lok Sabha at the union level. So the moment they lose their majority in the Lok Sabha, then that is a ground for their disqualification. They can be disqualified. That's very, very important. Now, once the government is dismissed, the appropriate word is dismissed rather than disqualification. Now, once a government is dismissed by the president, and therefore what can happen is he can also dissolve the Lok Sabha even before the completion of 5-year term. So this is one ground on which the Lok Sabha can be dissolved earlier, but not necessarily always the Lok Sabha is dissolved earlier just because there is a no confidence motion against the government. There is also a possibility that the Council of Ministers themselves advise the president to dissolve the Lok Sabha. Though they may have the majority, sometimes they may give an advice. So you may think that why the Council of Ministers have to advise the president to dissolve the Lok Sabha when they have a term. So sometimes the government or the Council of Ministers, they want to go for an early elections. There is a possibility that the political scenario or the political situation is favoring them to go for elections at that point of time. So they may go for an early elections also, but many times it has not happened in the history of India. So normally when there is a no confidence motion against the government, then therefore the Lok Sabha is dissolved. But however, under the constitution, the term of the Lok Sabha can also be extended. So normally what is the term of Lok Sabha? It is only 5 years. Can it be extended? Yes, under one circumstances it can be extended, when there is a national emergency in our country. We already discussed this. I have discussed this in detail during the national emergency topic. But anyways, for the students who are watching it newly, I'll discuss that right away. So we know that the president can proclaim national emergency under Article 352 of the Constitution. We know that the emergency can be proclaimed on the grounds of war, external aggression, or armed rebellion. These are the three grounds on which the president can proclaim the national emergency. Now, whenever the national emergency is proclaimed, under the condition the national emergency is proclaimed, then the term of the Lok Sabha can be extended. And how long the term of the Lok Sabha can be extended when the emergency is in force? The term of the Lok Sabha can be extended indefinitely. So this is very, very important. Indefinitely, but there are few conditions attached to this. Though the term of the Lok Sabha can be extended indefinitely, it can be extended only 1 year at a time. So how many years at a time, how much time it can be extended? It can be extended 1 year at a time. And who has a power to extend the life of the Lok Sabha? It is a power of the parliament to extend the life of Lok Sabha. So the parliament can extend the life of Lok Sabha, and at a time they can extend it by 1 year. So the parliament can make laws any number of times, and whenever they make a law, they can extend the life of the Lok Sabha by 1 year. So this is what basically you'll have to understand. So normally it does not happen, but under certain circumstances, the life of the Lok Sabha can be reduced, it can be extended. It can be reduced when there is a no confidence motion, and it can be extended when there is a national emergency. The authority to extend that is the parliament. By a law, the parliament can do that at a time 1 year, but otherwise it can be done indefinitely. But however, coming to the question of Rajya Sabha, the Rajya Sabha is a permanent house. As I already said, the Rajya Sabha is a permanent house. The Rajya Sabha does not have any term. But whereas there is a term to the members. And what is the term of the members? The term of the members is every second year there is election to the Rajya Sabha. And how this is possible is because, as I already said, in 1952, when the first Rajya Sabha was elected, after 2 years, 1/3 of the members retired. And after 4 years, the second 1/3 of the members retired. In the last 6 years, when the 6 years came, then the last 1/3 of the members retired. So therefore, it became a cycle that every second year the election happens to the Rajya Sabha. Therefore, the Rajya Sabha is a permanent house. But however, what is the term of the members? The house is a permanent house, but what is the term of the members? The term of the members is usually what is called as 6 years. So while the members have a term, whereas the house is a permanent house. In Lok Sabha, the term of the members is coterminous with the term of the house. As long as the house is there, the members will also be there. So this is the basic understanding you should have. Alright, so with that, I'll move to the next important topic, is the qualifications and disqualifications of the members of the parliament. So qualification means what are the qualifications as a person one has to possess so that they are eligible to contest election to the Lok Sabha and the Rajya Sabha. So for example, many of the students who are watching this, it's very important for you, because tomorrow if you want to contest election to the Lok Sabha, or tomorrow if you want to contest election to the Rajya Sabha, you should have an idea as to what are the qualifications you have to possess. So these are the qualifications one has to possess to contest the election. So what are those qualifications? So first and foremost, one should be a citizen of India. So what the constitution says, only a citizen of India can represent the people. Only they can become a member of parliament. So it can be a natural born citizen or a naturalized citizen. So here there is no distinction of natural born or naturalized. So in fact, the concept of natural born or naturalized does not exist in our country. So the only requirement is you should be a citizen of India. Okay, you are a citizen of India, then what are the other conditions? You should take an oath or affirmation in front of an authorized authority in a prescribed form. The oath has to be taken in a prescribed form. Anyone who wanted to contest election, and in front of whom you will have to take the oath is in front of the authorized authority, and this authorized authority will be appointed by the Election Commission of India. So the Election Commission of India is the one which is going to conduct election to the Lok Sabha and the Rajya Sabha. So therefore, in front of whom you will have to take this oath? In front of the authority that is appointed by the Election Commission of India. So the Election Commission of India will appoint the authorized authority. So who usually the Election Commission of India, which appoints authorized authority, is called as the returning officer. So usually he is a government officer who is a senior government officer at the district level, usually can be an IAS officer also. So who is appointed as a returning officer. So in front of the returning officer who wanted to contest election to Lok Sabha, they have to, or the Rajya Sabha, so they have to, usually in front of the authorized authority, so they have to take the oath. And apart from that, what is the age? So the age is usually 25, not less than 25 years, or attained 25 years in case of Lok Sabha, and attained 30 years in case of Rajya Sabha. So in fact, one of the students once asked me why the age is more in case of Rajya Sabha, because the Constituent Assembly thought that whoever is part of the Rajya Sabha, they are considered to be House of Elders. So therefore, the age limit is also little higher. So in case of Lok Sabha, it is 25 years, and in case of Rajya Sabha, it is 30 years. So these qualifications are given in the Constitution itself. So this is exactly what you'll have to keep in your mind as to what are the qualifications which is given in the Constitution itself. Well, these qualifications are given in the Constitution. Apart from that, certain other qualifications also prescribed by way of a law that is made by the Parliament. Now, this is not the exhaustive qualification. So, what are the qualifications given in the Constitution? These are the qualifications, but this is not the only qualifications. Apart from that, what the Constitution is saying? The Constitution is saying that the Parliament can make a law, and by that law they can prescribe certain other qualifications also. So what are the other qualifications as may be prescribed by an Act of Parliament? The other qualifications include what is called as the Representation of People Act 1951, or in other words, the other qualifications are prescribed by the law made by the Parliament, and that is nothing but the Representation of People Act. So what is the Representation of People Act is saying? Anyone who wanted to contest election either to Lok Sabha or to Rajya Sabha, in addition to these qualifications, they should also be registered elector from any constituency in India. So how many constituencies are there in India? We already discussed this. There are 543 constituencies in India, including all the 28 states and the 8 union territories presently. Out of this 543 constituencies, you should be a register in any constituency in India. When I say you should be a registered voter in any constituency in India, that means you should possess a valid voter ID. And because you possess a valid voter ID, you are also eligible to participate in the voting. And because you are eligible to participate in the voting, or you are eligible to be a voter in the election, you are also eligible to contest election. So that means the basic condition to contest election is what? The basic condition to contest election either to Lok Sabha or to Rajya Sabha is basically you are a voter in the first place. So therefore, if you are not a voter in the first place, you are not eligible to contest election in the first place. So this is very, very important. So only an eligible voter can do what? Only an eligible voter can contest the election. So that's a basic understanding you should have. You are registered elector from any constituency in India. Doesn't matter in which constituency in India. Wherever you want to contest election, it does not matter. In any constituency in India, you should be an eligible voter. Apart from that, if you are someone who wanted to contest election to a reserved constituency, in the previous class itself, we have discussed that there are certain seats which are reserved as a scheduled caste and a scheduled tribe constituency. And which constituency is to be reserved for scheduled caste and scheduled tribe? It is a duty of the Delimitation Commission to decide that. But however, we have understood that the Delimitation Commission will do that on the basis of the population, and the population that is taken into account for this particular purpose is 2001 census. So we discussed all those things in the previous class itself. So if you want more detail about the Delimitation Commission, you can go back to my previous lecture and you can understand as to what is the Delimitation Commission does in our country. But anyways, one of the conditions for someone to contest election from the reserved constituency is that they should possess all these conditions. Should be a citizen of India, should be taking an oath or affirmation, should fulfill the age requirement, should be a registered voter in any constituency in India. And apart from all those things, he should also belong to a reserved community in that particular state or anywhere in India, does not matter. That means anyone who wanted to contest election to the scheduled caste reserved constituency, they should be a member of a scheduled caste from that particular state where the constituency is there or anywhere in India. Anybody who wanted to contest election to the scheduled tribe reserved constituency, they should belong to a scheduled tribe community or in that particular state or anywhere in India. So in addition to all the other qualifications. So these are the qualifications one has to possess to contest the election. Unless and until they fulfill all these qualifications, they will not be able to contest the election. So it is must. So you should also be aware what are the qualifications given in the constitution and what are the qualifications not given in the constitution, and what are all based on the Representation of People's Act. All right. So the next thing is disqualification of members of the parliament. So there are two things that you have to understand. So first we have understood as to what are the qualifications. Qualifications are someone to contest the election. So if you want to contest the election, you should possess all those qualifications. But disqualification is for someone from being chosen as a member of parliament. That means even before getting elected as a member of parliament, they can be disqualified. Or someone who has been already elected as a member of parliament, they can also be disqualified. So this is what is about the disqualification of the members of the parliament. So disqualification from being chosen or disqualification of someone who is already a member of parliament. So these conditions are going to apply to both the categories of people, except for few exceptions, say like the anti-defection law only applies only to who is already a member of parliament, but otherwise most of the other disqualifications will apply to both the categories of people. So what are those things? So first is not a citizen of India or voluntarily gives up the citizenship. That means somebody has voluntarily given up the citizenship. That means then they are not eligible to contest election. Or someone who has already become a member of parliament and at that time he was a citizen, but after becoming a member of parliament he has given up the citizenship. Then also he is not eligible to get elected. Okay, so this is, or even if he is a member of parliament, but after becoming a member of parliament, as I already said, he gives up the citizenship, then also he can be disqualified. Next is someone who becomes an undischarged insolvent. Who is an undischarged insolvent? And an undischarged insolvent is usually someone who has taken credit from any financial institutions and they have taken loan or any credit from the financial institutions where they fail to repay it as per the terms of the contract based on which the loan was provided or based on which the credit was provided. Under such a circumstances, the financial institution can legally take action. Until the time he is cleared of those legal actions, until the time he has cleared of the debts or as per the legal provisions he has arrived at a final settlement, so he is considered to be what is called as an undischarged insolvent. So anyone who is an undischarged insolvent is not eligible to contest election to become a member of parliament, or someone if he is a member of parliament already, then he becomes an undischarged insolvent, then also he is liable to be disqualified. So that is what you will have to understand. Now the third thing is someone who holds what is called as an office of profit. So any member of parliament should not hold on to any office of profit. Someone who becomes a member of parliament should not hold on to any office of profit. Someone who wanted to contest election to the member of parliament should not hold on to office of profit. In both the cases, they are liable to be disqualified. So therefore, what is this office of profit? The biggest problem is, what is office of profit is nowhere defined in the constitution. It only says that it is a condition for disqualification. So what is this office of profit? We will only understand it by the definition that is given by the Supreme Court, that any office either under the central government or under the state government or under any of the other local authorities, by a way of which the profit is receivable, then such an office would be considered to be what is called as an office of profit. The key question that you have to ask is whether the profit is receivable or whether the profit is received. Whether the profit is received is immaterial. What should be seen is whether the profit is receivable in the first place, then that would be considered to be an office of profit. Say for example, if somebody is a government servant, any government servant, suppose let us assume a state government employee, can that state government employee contest election to become a member of parliament being in that employment? No, it is not possible, because he is an employee of the state government, he receives a salary. He may not even receive a salary. He can write it to the government saying that I don't want the salary. But still the salary is receivable. Whether he is taking it or not taking it is immaterial, but whether the office provides for the salary is what is very important. So if the office provides for the salary, then automatically it would be considered to be what is called as an office of profit. So therefore they are liable to be disqualified from contesting election. So similarly, someone who wanted to contest election, can they be a government servant? No, they have to resign from that particular post, then they can contest the election, but not holding on to that particular office, because that is an office of profit. What about someone who is elected as a member of parliament? Someone who is elected as a member of parliament, can they occupy any government post? They should also not occupy any government posts, because one of the conditions for disqualification of a member of parliament is also they should not hold on to any office of profit. So therefore, try to understand office of profit is a valid ground for disqualification. So that it means that a member of parliament is also a minister. Sometimes a member of parliament also becomes a minister. Not all the member of parliament becomes a minister, but some of the members of the parliament is appointed as a minister. Say for example, Mr. Amit Shah is a minister, Mr. Narendra Modi, who is the prime minister, is a minister, but they are also members of parliament. So does it mean that they are liable to be disqualified on the grounds of office of profit? No. Although they hold an office of profit, no doubt, but the constitution allows the parliament to exempt certain officers from being office of profit. That means the constitution is giving the power to the parliament to make a law, and by that law they can exempt certain office from being what is called as an office of profit. So accordingly, the parliament has enacted what is called as Parliament Prevention of Disqualification Act 1959. So under the Parliament Prevention of Disqualification Act 1959, they have made a law and they have exempted all the ministers from being considered to be what is called as an office of profit. So therefore, to say that a member of parliament should not occupy any executive post is wrong. But a member of parliament, if he occupies any executive post which is not exempted under this particular law, then that would be considered to be an office of profit. And therefore, they are liable to be disqualified. So that's a basic understanding you should have. So anyone who is not a citizen of India or voluntarily gives up the Indian citizenship, or someone who becomes an undischarged insolvent, or someone who holds office of profit, provided the office of profit is not exempted under the law, or someone who becomes unsound mind. So what does it mean by unsound mind? Unsound mind means someone who is declared to be mentally unsound by a competent court because of certain mental disorders and other things. Someone who is declared to be so, then they are also not eligible to contest election. Or if a member of parliament becomes unsound after that also, he is liable to be disqualified. So these are all the various grounds for disqualification for both from getting elected as a member of parliament, and if you are already a member of parliament, from continuing that particular post. In both the cases, they are liable to be what is called as disqualified. So this is the basic understanding you should have. So apart from that, if you see as to what are the other grounds for disqualification, while certain grounds are directly mentioned in the constitution, apart from that, what the constitution is saying, the constitution is also saying that we give the power to the parliament. So who is giving the power to the parliament? The constitution is giving the power to the parliament to make a law, and by that law also you can prescribe certain conditions based on which a member of parliament can be disqualified. So accordingly, the law that is enacted by the parliament is the Representation of People Act. So the Representation of People Act, apart from the constitution, provides for certain grounds. So now whatever we are going to discuss is under the Representation of People Act, not directly mentioned in the constitution. Earlier, whatever we have seen is directly mentioned in the constitution. So apart from what we have already seen, which is directly mentioned in the constitution, the Representation of People Act is saying, okay, these are all the grounds on which they can be disqualified. So what are the grounds on which they can be disqualified? So first is someone guilty of any electoral offense or corrupt practice. Someone who is guilty of any electoral offense or corrupt practice, then they are liable to be what is called as disqualified. So what do you mean by an electoral offense or a corrupt practice? Engaging in bribe during voting, coercing people to vote, any undue influence upon the voters during the elections, these are all considered to be corrupt practice. So someone who is engaging in the corrupt practice, they are liable to be disqualified from contesting election. Or if a member of parliament has won the election by the corrupt practice, then he is liable to be disqualified as a member of parliament. So both the cases you will have to understand, but again this is there in the Representation of People Act. Apart from that, somebody who is convicted of 2 years or more for any criminal offense, then they are liable to be disqualified. Suppose somebody is convicted for 2 years or more even before contesting the election, then they are liable to be disqualified from contesting election, not only for the term of imprisonment, but also for another 6 years. Say for example, you might remember Mr. Rahul Gandhi was recently convicted in a court of law, and he was convicted for what is called as criminal defamation. If you do not know, you can make a little bit of research. Mr. Rahul Gandhi was convicted by a local court for criminal defamation. It's a criminal defamation. It's a criminal offense. Defamation in India can be both civil as well as criminal offense. But the charges against Mr. Rahul Gandhi was criminal defamation. So he was convicted for criminal defamation. So what was the punishment he was given? He was punished for 2 years of imprisonment. So therefore, if this 2 years of punishment is to continue, Mr. Rahul Gandhi will not be able to contest election for the term of imprisonment plus another 6 years. That means for 8 years, you won't be able to contest election. I think this happened in 2024, early 2024. But however, subsequent to that, Mr. Rahul Gandhi has gone for an appeal to the Supreme Court, where the Supreme Court stayed the conviction. So therefore, he again became a member of parliament, and then he was allowed to contest the elections in the 2024 elections. Suppose if this conviction was not stayed by the Supreme Court, then Mr. Rahul Gandhi would not be able to contest election for another 8 years. So therefore, this is not only to Mr. Rahul Gandhi, it can apply to any member of parliament who is convicted for any criminal offence for 2 or more years. So similarly, if someone who is not a member of parliament, he is just an ordinary citizen, and if that ordinary citizen is convicted in a court of law, if the conviction is 2 or more years, then also they are not liable, then also they are not eligible to contest election for another 6 years after completing the conviction term. So this is basically what you'll have to understand. There's also another ground for disqualification of a member of parliament if they fail to lodge what is called as an election expense. Suppose somebody contested the election, they won the election, but after winning the election, they have to file the expenses that they have incurred during the election process. As per the Representation of People Act, there is a limit to what extent they can spend during the elections. If you see the Representation of People Act, anyone who wanted to contest election to the state legislature, they can spend up to 28 lakhs to 40 lakhs. So depending upon whether it is a big state or a small constituency, big constituency, the range is there. 28 lakhs to 40 lakhs. I think in case of Lok Sabha election, it is 70 lakhs to 95 lakhs. So that's the range. So within that range, they have to spend, and for which they have to maintain a specific account, and through that account, they have to make all the expenses for the elections. And after the election is over, within a period of 1 month, they have to file this account and the expenses in front of the Election Commission of India. If they fail to do that, then they are also liable to be disqualified. And then apart from that, anybody is convicted for certain offences. Don't get confused between this. So here it is saying conviction for any offence for 2 or more years. It can be any offence. Does not matter what type of offence. But here it is saying convicted for certain types of offences and the laws which is specified in the Representation of People Act itself. So here the offences is not specified. Which law based on which they are punished is not specified. It can be any law, but the only thing that you have to take into consideration, what is the quantum of punishment, whether it is 2 years or more. But here there are certain offences which is specified one after the other in the Representation of People Act. Say for example, in the Representation of People Act, certain offences are specified like hate speech, the crime of hate speech, the crime of any crime under the Prevention of Corruption Act, or anyone who violates the Protection of Civil Rights Act. What is the Protection of Civil Rights Act is all about? It is dealing with the practice of untouchability. In fact, it is created or it is enacted with an objective of doing away with the practice of untouchability. So anybody who is punished under these offences, be it hate speech or under the Prevention of Corruption Act or under the Civil Rights Act, not necessarily only under these laws, the list of laws which is given in the Representation of People Act. You don't have to remember all these laws, but remember at least these laws. Now, whatever law which is specified in the Representation of People Act, and if the minimum punishment under these laws is not important. So if they are found guilty under these laws, that itself is sufficient enough for them to be disqualified. So even if the punishment under these laws is fine, then they are disqualified for another 6 years. If the punishment is 1 year, then 6 plus 1 year, 7 years they are disqualified. So while in these cases, if they are found guilty, then they are disqualified. They are disqualified for another 6 years apart from the year of conviction. But in other cases, if the punishment is not on these offences or not on these laws, but on any of the other laws which is not explicitly mentioned in the Representation of People Act, in those cases the minimum punishment has to be 2 years. And if the minimum punishment is 2 years, then they are liable to be disqualified. Otherwise, they are not liable to be disqualified. So this is a basic understanding you should have as to what are the grounds on which they can be disqualified. So I'm sure that it is very clear to all of you. So what is very important for you to remember is, what are the grounds on which you will have to understand disqualification can happen, which is directly mentioned in the Constitution. What are the grounds on which disqualification can happen, but not directly mentioned in the Constitution based on the Representation of People Act. Now, apart from all those things, there was one more provision that was added as a ground for disqualification, though they were not mentioned in the original Constitution, is the disqualification on the grounds of anti-defection law, which was inserted as a ground for disqualification under Article 102 of the Constitution for the members of the Parliament and Article 191 for what is called as the members of the state legislature. So in the next lecture, what we will do is we'll try to understand as to what exactly is this anti-defection law, what are the various provisions of anti-defection law, what are the various exceptions to anti-defection law, what are the lacunas today with regard to the anti-defection law. So we'll try to understand all those things in the next lecture. So with that, we are coming to the end of this particular lecture. But before I complete this particular lecture, let us try to solve this particular question very quickly. In fact, I wanted you to solve this particular question. So consider the question. Which of the following are the grounds for disqualification of a member of parliament under the Constitution of India? That's a question. Office of profit, conviction for 2 years or more, unsound mind, anti-defection law. Choose the correct answer from the quotes given below. I wanted you to have a clear idea as to what are the disqualifications given in the Constitution. Disqualification under the Representation of People Act. So with that, we are coming to the end of this particular lecture. If you like this particular lecture, please share it with your friends and family members. And I'm sure that it is going to be extremely useful for the students preparing for IAS examination. If you have any questions, doubts related to the civil service preparation, you can reach out to me. Think me as a friend, mentor who can help you in your success. And this is going to be immensely beneficial. Thank you very much for watching this particular lecture. All the very best.